The leasehold. In other words, it's a lease. We're going to talk about leases and how they come about and why we use leases in real estate. Leasehold estate is an estate created when the owner of property, known as the lessor or landlord, conveys a possessory interest in the real property to another, known as the lessee or tenant, for a specific period of time in exchange for the tenant's payment of rent. In other words, they loan it to somebody and it reverts back to them when the lease is done. Tenancy is an estate for a specified period of time that has a specific beginning date and specific ending date. When the ending date arrives, the estate is terminated without notice by either party. So they don't have to give notice, the lease simply expires. It may be for days, months, or years. In Ohio, when we deal with real estate, anything that's 1 year or longer has to be in writing. Keep that in mind, and that's something you need to know, that anything that's 1 year or longer, when it refers to a lease, has to be in writing. A periodic tenancy is an estate from period to period, continuing from period to period until terminated by proper notice from one of the parties. Periodic tenancies can be compared to gentlemen's agreements. Many years ago, they came together, they agreed, hey, you can live here, and as long as you pay your rent, you can keep living here. And with that periodic tenancy, it's gone on for the last 20 or 30 years because they keep paying their rent. Every now and then they're told their rent's going to increase, but they keep paying the rent. They haven't entered into a new lease, but there's a gentleman's agreement or something that's in effect that the person knows that they can keep staying there. That's a periodic tenancy. They pay their rent, they continue to stay. Tenancy at will is a tenancy that exists until either party chooses to terminate it. So tenancy at will is any good business relationship, or renting an apartment, an office building, or shopping center, something like that. As long as everybody agrees to the terms and they're paying rent, doing what they should be doing, it's considered a tenancy at will. Everybody's happy with it. Everybody's living by the agreement. Tenancy at sufferance, a little bit different. It's created when a person is wrongfully in possession of another's land without a valid lease. So how are you in possession without a valid lease? Well, if you're not paying your rent, you're still in possession. It's a tenancy at sufferance. You might not pay your rent because you have a beef with the landlord because they're not maintaining something properly. There's a way to deal with that by paying your rent into the court, into an escrow account at the courts, and the courts will help you, but that could be considered a tenancy of sufferance because the landlord isn't doing what they need to be doing, and you're not paying your rent, but you want to make sure you're protected as the tenant that way. So again, they're not paying rent typically, and that's a tenancy of sufferance. Holdover tenant is one who failed to vacate or surrender possession of the premises on the ending date of a term tenancy. In commercial real estate, we have a holdover tenancy. There's actually a provision in most leases say that if you don't renew your lease, if you don't get back to the landlord at a specific period of time, you're subject to holdover rent. In my case, in a lot of cases, it's 150%. Or there's a $200 on an $800 rent. The holdover rent may, instead of being $800 a month, is now $1,000 a month. Again, so we enforce these provisions, and the reason we do as a landlord is we want the tenant to come back to us and negotiate a new lease. So by enforcing a holdover rent, we're charging them more than what would be their market rent, but it's forcing them to react and actually sign a new lease. The lease is a contract, either written or oral, that transfers the right of possession of the premises to the lessee or tenant. So again, we're giving them possession to maintain, to use legally during that period of time that lease runs. The property will revert back to us as the landowner, though. The essential elements of the lease is a valid contract. Again, a lease is a contract. If it's for 1 year or longer in the state of Ohio, it has to be in writing. There's mutual consent. Both parties are entering into it voluntarily. Supported by consideration, rent. We see a lot of clauses in some of our terms in the leases where we do renewal provisions, or we give options where we'll say that they're given this for $1 or $10 and other valuable consideration. We don't exactly exchange that dollar or pass that dollar, but in terms of the agreement, we put that consideration in there so that we can see that it is supported by that consideration. Consideration doesn't always have to be dollar rent. Consideration can be services exchanged for the ability to be there, to be maintaining or doing something. So consideration is not always money rent. It might be services. The mutual intent for a tenant to have possession and landlord retains a reversionary interest in the land. Again, the building is always going to go back to the land, to the landowner, to the landlord. And capacity of the parties. They have to be legal age, not minors. They have to be of sound mind, because we can come back and challenge all these things and say that it's no longer a valid lease because of that. Again, necessitating written documentation of the lease exceeds 1 year to prevent fraud. In Ohio, any agreement longer than a year, 1 year or longer, has to be in writing. That's by the statute of frauds. Again, more essential elements. If the entire conveyed premises are being leased, legal description of the deed is typically satisfactory. If you're doing an industrial lease and you're leasing not only the land, the building and the parking lots and everything like that, or a triple net lease like a Walgreens on the corner or McDonald's or something like that, you may want to go ahead and put a full legal description that, like the deed, to say this is what they're entitled to. It's not just an address. If something less than all the premises is being leased, usually the lease will state clearly what it is to be leased. For instance, apartment 9 within this building or suite 100 in this building will be specific, but that's enough. You don't have to do a legal description. You're specifically just stating what the premises are by the actual post office or description. The beginning and ending dates of the length of the term has to be specific, have a beginning and an ending date. Courts do not favor leases of unlimited duration. Some courts have held that leases that are too long are barred by the statute. In other words, barred by statute of frauds. The compensation paid by the lessee for the possession of the leased property. What's going to be paid? Again, a compensation doesn't have to be rent, money, but it might be services or goods. But it's very specific in the lease. How will it be done? Normally money, but could take forms of value percentage of crops harvested from land or relief of the lessor, an obligation owned to the lessee. Again, we may have somebody staying on our premises that has a good hand and they can do remodeling, and we let them stay there for a year while they're doing certain remodeling to turn the building around or do something like that, goods and services. How much, when, and where the rent is to be paid. Years ago when I started in this industry, we actually collected rent in the management office. We don't do that anymore. We actually collected cash too. We don't do that anymore either. We tell our tenants very often today that they have to pay their rent toward a lockbox because we're using lockboxes to do a lot of our cash processing today. We also used to carry guns because we would go to every day we would take money to a bank, or if we're actually going around to tenant to collect rent. I had a maintenance guy that worked for me years ago. He owned a lot of property in over the Rhine, and he would walk tenant to tenant at the first of the month and collect his rent in hand. Again, not the best way to do it, but what was done at the time. We've changed times today with electronic banking, things like that. But the rent is very specific, has to be stated in the lease. When's it late? What's a late fee? Is it after the 10th of the month, and what is the late fee to be? That's all stipulated in the lease. The legal use of the premises. When not indicated, the lessee can make any legal use of the land. In shopping centers, very often we're saying that it can be a retail use, but we limit the retail uses. We don't want a conflicting interest or a competitor interest to come in. So we may have restrictions with competing uses. But again, when it's not indicated, it's any use of legal use of the land. But a lot of our retail leases have restrictions. Office leases, that it has to be used for a specific office type use. Residential leases, sometimes they don't want people to do work out of the apartment. Today that's changing a little bit because a lot of people can do work just with a computer or laptop, but they may not want a business run out of the apartment. So again, what are the limitations? The courts will uphold those limitations that are designated in the lease. So we want to be specific if we have rules and regulations about how something is being used or leased. Rights of possession. In all jurisdictions, the right of possession implicitly resides in the tenant. No one will have possessory rights inconsistent with those granted to the tenant. Another thing we want to ask about is when does the tenant have possession? Is it when they were given the keys? And that's great and that's fine. In commercial leases, very often they're given the keys at one point in time, but the rent may not start until months later. So what's possession? It's very stipulated. And when you have possession, you may not pay rent, but you might be responsible for insurance and doing certain things and utilities. So that would all be written in a lease. Recording a lease. It's permitted in most states because a lease is a conveyance of an interest in land. Uncommon to record residential or other short-term leases. We don't see apartments being recorded. More likely to record leases of 3 years or more. In some instances, I've seen commercial leases where they say that it will not be recorded. But if I'm a tenant and I'm putting money into my storefront and I'm going to have that storefront for 3 to 5 to 10 years, and I've made quite an investment, I want to record that lease because I want to be able to tell the public and any potential lender or investor in that property that I have this leasehold right. I'm going to have possession for so many years, so I want to record that lease. That's when we see leases get recorded. And very often they're called memorandums of lease. They're short forms. They're just a few pages. They talk about the time period of the lease and what it can be used for, but they don't put through like the rent dollars paid and some of the things that are confidential information would not be in a memorandum of lease. Types of commercial leases. You will not need to know all this for your real estate exam, but it's interesting to know if you end up doing any type of commercial leasing, there are various types of commercial leases, and these are based on how rent is paid or looked at. We have a gross lease, a lease in which a flat or fixed amount of rent is paid by the tenant. Very often we see gross leases in office buildings where the landlord is taking care of everything, does all the janitorial, does all the security, does all the building maintenance, but they charge a flat fee, which may be called a gross lease. A net lease, as contrasted with a gross lease, is a typical lease in which the tenant agrees to pay the taxes, insurance, and repairs and other operating expenses of the premises, usually on a pro rata basis if multiple tenants are involved. I have net leases in all of my shopping centers where the tenants pay their pro rata share of the taxes, the insurance, and all the expenses to run the common areas of the building. They pay me a base rent for their space, but then they pay the additional costs considered in a net lease. A ground lease is a specialized type of net lease in which the lessor leases a piece of vacant land to the lessee, usually with a stipulation the lessee at his or her own expense will construct the building thereon. We'll see ground leases very often with Walgreens or CVS's at the corner. They build their own building, they do a ground lease. McDonald's, they do ground lease. They build their own building, but they'll pay that rent. Not only do they pay the rent on the ground lease, but they take care of all the taxes, all the maintenance, insurance, utilities, everything required to use the building that they put on the land. So the ground leases are great for investors. They have no worries, no cares. They simply sit back and collect their rent check every month or every year, depending on how it's paid. Percentage leases is a lease whose rental is based part on the gross sales made by the tenant on the premises. Percentage leases are very common in retail. They're less common than they used to be. We used to do percentage rents. When we do percentage rents, though, it's not somebody that doesn't know what they're negotiating. We have this International Council of Shopping Centers that produces books that talk about what the rates are for doing leases in particular types of centers, particular types of businesses. So the person who's negotiating a lease on behalf of the landlord and on behalf of the tenant, they know what their target goals are when they're negotiating this percentage rent to say, okay, if my sales exceed $500,000 every year, then I'm going to pay this X percentage in addition to my base rent because I was performed as a percentage tenant. The landlords like this percentage rent because the landlords say, hey, wait a minute, we build a good center, we're doing a lot of promotional activities, or we're doing such a good job maintaining our center that we make people want to come here. We get the people, the foot traffic here, and therefore we get to get part of that as part of your business, part of that percentage rent. I only have a couple of leases anymore in my retail centers that have percentage rent provisions in them. Again, most of them are more of a net type lease, but we do still see percentage leases. Index lease, tenants leases tied to a particular index, very common. Most leases are tied to a particular index when they're long-term leases. But they may not be tied to an index. They may have a step up in rental where the rent increases 50 cents per year per square foot. Or the index lease would say, okay, based on the consumer price index, the lease will increase in flow based on how the CPI increases. That I don't see as common as it used to be, because the CPI, while it's a good indication of what's going on in the economy, it's not the best indicator for the landlord or the owner of real estate, because the CPI does not always take into account utilities and taxes, which are two of the largest owners' expenses when they own investment real estate. Lease renewal. Depending upon the type of leasehold, the lease will terminate on its own or appropriate notice by either party. The renewal is a new lease. We see them as first amendments or amendments to the lease, but they do tie back to the lease, but because the amendments are done, they basically are creating a new document. And we can also renew our lease by holding over. Very often in residential leases, we'll go back to our tenants 60 to 90 days before a lease expires and say we want you to renew your lease. With a commercial lease or retail lease, we may go back to our tenants anywhere from 6 months to 9 months before a lease expires and go back and get them to renew. If you're a real estate broker, part of your business is knowing when leases expire, and you're out there in the marketplace a year before leases expire, trying to call on those tenants to get them to be your clients. Or if you're representing the landlord, you're calling on the tenants to know what they intend to do. How's their business going? Do they want to stay in the premises? Things like that. And that's it for our lesson on leases.